Good afternoon, everyone. This is Alfred Sanchez. I'm the president of the Greater Miami Chamber of Commerce, and I know that we have many participants that are supposed to be coming on, and I think as folks make their way into the Zoom verse, we'll give them a chance to do that before we actually start. So please bear with us just one moment. For those of you who are just joining, we've just opened up and we've got about 150 folks online so far. I think we're expecting close to 300. So we're going to give folks just a few minutes to settle into the Zoomverse, and then we'll get started. We have a great program for you today. Thanks for joining us. We're getting close to 200 folks. We were expecting about 400. So we're going to give just a couple more minutes to make sure that people make their way inside the Zoom room, and then we'll get started. Thank you for joining us today. Okay, we're just about at 200, so I'm going to go ahead and get started. Not to punish those who arrive on time, like we're known to in Miami. So this is Alfred Sanchez. I'm the president and CEO of the Greater Miami Chamber, and we welcome you all to our new reality, which is the Zoomverse, the Zoom rooms, and I think we're all have been become sort of graduated from the baby Zoomers, and now we're adult Zoomers, and so we're used to this whole new reality. We've got a great panel of folks today that are looking at the HR and legal issues around the COVID reality and some of the stuff that's going on. So we're going to turn that over in a second, but I want to let you know that the Chamber is putting on a long series of these over the next few weeks. So please look for those as we communicate it out to you. We will be doing on Thursdays at 1 from now on a series of roundtable discussions with leading experts and CEOs. We've had the mayor on, and so look for those because the content is going to be extremely important, and that's the Chamber Roundtables on Thursday. Today we have El Panye Hudson, who is the VP of HR for FIU, and we have Patrick Martin, who's the co-chair of our HR committee, who have really taken the lead to put this together. I want to thank you both for your leadership in this and the HR committee's wonderful work on putting this in a very quick fashion to really benefit our members. Ike, I want to turn it over to you, and I want to thank you again for putting what I think is going to be a terrific panel and a terrific discussion. We will have questions at the end, and I know you're going to tell everybody how to do that. Thank you very much, and welcome everybody.
Thank you. Thank you so much, Alfred. We really appreciate your leadership and your support. And good afternoon, everyone. Welcome, welcome, welcome to the HR Insights webinar in lieu of our annual HR Insights conference. I want to thank all of our committee members. You've worked so hard and we appreciate your work. I also want to thank the Jim Sherm team for their partnership on facilitating this webinar with us. They continue to be great collaborators with us, and we really appreciate the relationship. I, as Alfred noted, bring you greetings from Florida International University, where I have the honor of serving as Vice President for Human Resources, and I'm privileged to serve as the chair of this HR and Professional Development Committee here with the Chamber. While we regret not being able to host our customary event in person, we are committed to making sure that you still receive quality content and programming that you're accustomed to by our committee. I want to thank all of you for joining us. For most of our organizations, the unthinkable has driven us to redesign the way we do business on so many levels. For instance, while remote work is not new to most of us, forced remote work is a different animal. And the effects of the global pandemic, while not to be lauded, it has tapped on the resiliency and creativity of mankind in ways we did not imagine. It's moved many of us out of our comfort zones and taken us to places we've never experienced before. Our government, as many have across the globe, has recognized the crippling effects of the pandemic having on our businesses and our economy, and they've passed legislation to help us traverse this unfamiliar place with resources embedded in the Families First Coronavirus Response Act. So today we're going to borrow from the profound Chinese proverb, which says to us, it's better to light a candle than curse the darkness. And to that end, through the lens of a few accomplished and insightful colleagues, we're going to shed light on information that's embedded within the FFCRA and allow opportunity for you to ask questions so you can leave this webinar with greater clarity on the features that would benefit you and your organization. So with that, allow me to introduce our outstanding speakers for today. The first will be Michael Mueller. He's a litigation partner at the law firm of Hunton Andrews Kurth, where he is based here in Miami as well as in Washington, D.C. He has 33 years of experience with labor and employment cases, including more than 60 private class actions involving claims under the Federal Fair Labor Standards Act. He's also defended his clients against two of the largest U.S. Department of Labor enforcement actions in history involving claims under the FLSA. He's taken to trial perhaps more class and group actions than any other attorney in the country, with nearly 200 trial days in federal court, the majority of which have resulted in no payouts by his clients. Mike has earned multiple awards for his aggressive, innovative, and successful track record, including the American Lawyers Litigator of the Week, the National Law Journal's Litigation Trailblazer, and Law 360's Class Action MVP. How impressive is that? And then I want to bring to your front Aaron Tandy. He's a partner with Patham Lewis and heads the employment law section and has over 25 years of experience advising HR managers and departments on developing employee programs and policies. He helps businesses navigate federal, state, and local employment laws and assists businesses in developing employment policies and programs for a productive and positive work environment. That's so important in what we do. Aaron places a special focus on resolution of business torts, regulatory and administrative hearings, employment and HR litigation, and e-commerce and intellectual property disputes, including the gathering and proper use of electronic and social media evidence. In addition, he provides counsel to the entities looking to comply with federal and state antitrust laws, including the establishment of domestic and international distribution agreements and joint ventures. Last but certainly not least, our esteemed moderator and vice chair of the HR and Professional Development Committee, my colleague and friend, Patrick Martin. He focuses his practice on employment law matters, representing employers of all sizes before state and federal courts, as well as administrative agencies such as the Department of Labor, the Equal Employment Opportunity Commission, and the Florida Commission on Human Relations. In his practice, Patrick regularly litigates cases involving wrongful termination, employment discrimination, workplace harassment, public accommodation, wage and hour matters, and employee disability and leave issues. In addition to his litigation practice, he advises employers on preventive strategies to minimize potential litigation and assists in the development of policies to promote constructive employee relations. Patrick also assists employers on personnel matters and emphasizes the importance of striking the correct balance between the business and legal issues that arise in human resources decisions. Now, if we were in a room, you guys would make a big round of applause for all of these great presenters that are going to come before us, and you will know that you're hearing from the experts. So with that, allow me to turn it over to Patrick.
Thank you, EK. That's a wonderful introduction. And yes, we normally get that Panther Pride celebration once you're finish with your introductions. Good afternoon, everyone. I'm very excited today to moderate this panel between two esteemed colleagues of mine, both Aaron and Michael, who we've worked together on the HR committee for quite some time now. And we're going to, obviously we're going to do a webinar today on the FFCRA, the Family First Corona Response Act, and then also the CARES Act. What I wanted to do is sort of talk to you about the game plan, the sort of the game plan that we anticipate going through today. Last week we had a webinar in which there was an excellent overview of both of the statutes, and since then we've received quite a bit of guidance from the and interpretation from the federal government, from the DOL in particular, and it's being updated regularly and on a daily basis. So much so I haven't even had time to shave. So what I've done is spend a lot of time reading up on these, and so has Michael and Aaron today. But our intent is to focus in on the FFCRA and some of the practical, and then also some of the practical employment law issues that HR professionals are having to face because of this current crisis that we're going through. And so we were not going to spend as much time, that was last week, in terms of an overview of the statute itself, but we'd like to go through some common questions that have come up since then. So what we're not going to do is go into the CARES Act today. We're not going to, for example, we're not going to spend time on the loans and the unemployment benefits and the tax credits, issues like that. That is going to be the subject of a whole nother webinar. In fact, our intent as the HR committee is to prepare a series of lunch and learns in which we can go through the various types of HR topics that are be coming up, and certainly the CARES Act and some of the issues and questions that come from that will be something we can devote a whole other webinar to. So and we'll be partnering up with Jim Sherm on that as well in terms of some of the HR issues, and again, we intend to have a series of lunch and learns that'll go through that. Today we're gonna allow both Michael and Aaron to go through their some materials, some general overview, but really what we're going to spend a lot of time on are your questions. And obviously we'll have some things to talk about, but I anticipate you guys will be active, as all the webinars that I've been on so far and participated in. There's been a lot of interest, a lot of questions that have come up. So please submit your questions through the chat function. We have folks that are going to be gathering them, as well as I will attempt to do so as well, but we'll filter them through and hopefully get to all of them as much as we can. Don't get upset with us if we don't get to your question. We will provide you all with our email addresses, and we promise to be available to you to answer any sort of questions that we don't get to, or maybe questions that we will need a little bit more time and guidance to respond to. So with that, let's get started, and we're going to first hear from Michael, and then from Aaron, and then again we'll go into questions once they're done. Michael, you can take it from here.
Thank you, Patrick. Good afternoon, everyone. Thank you for joining us. The FFCRA, as you probably know, is part of the third wave federal legislation in response to the COVID-19 pandemic. There are two major parts to the FFCRA. Part of it is emergency paid sick leave, called the Emergency Paid Sick Leave Act. That's abbreviated EPSL, and that's how I'll be abbreviating it in my slides. And the other part is the emergency FMLA. I've seen it variously referred to as expanded FMLA or EFMLA or FMLA plus, but they're all referring to that part of the FFCRA. Obviously, right now, employers and their HR departments are facing a tsunami of legal and HR issues while trying to keep their businesses afloat. The current legislation was rushed and it is confusing, but as Patrick mentioned, the U.S. Department of Labor has been issuing rolling waves of Q&As, or you might call them FAQs, since March 24 to create some clarity for employers. At the end of this presentation that I'm giving, you'll see a link to those FAQs, which now number up to 79. They're going to issue more FAQs in the future. They've said so. So if we don't address something in this presentation, click on that link. The presentation will be available to you at the end, or at least later today. and you can get some answers directly from the Department of Labor website. In addition, on April 1st, the Department of Labor issued 124 pages of regulations that implement the statute. They largely track their Q&As on the Department of Labor website, but they're not entirely the same. There are some things only the regulation addresses, and they're not addressed in the Q&As. Both the statute and the regulations are in effect through the last day of 2020. So just this year, it's considered temporary legislation. Today, we'll be covering some of the highlights of the FFCRA. I'll cover the DOL regulations, and then Aaron will cover some HR issues raised by them. In addition to the link at the end, I provide various other links to other resource materials, both on my law firm and on the Department of Labor website. One other thing I want to point out before I get into my slides is the Department of Labor is considering comments from businesses through April 10th. So you have a little bit of time still if you want to make any comments. The department will use ideas and comments to develop compliance assistance, guidance, resources, and outreach approaches to assist employers and employees. You can make those comments at www.dol.gov. Let's go to the first slide. So I'm going to do just a quick recap here if you didn't listen to Alan Norton's presentation last Thursday. The most important thing for you to know is the FFCRA only applies to employers with less than 500 employees. That is 499 or less employees. This is literally a product of lobbying. Large employers managed to convince Congress not to include them in the statute. For purposes of the counting, that is the 499 or less, obviously companies can change in size, especially if they're starting to rehire later this summer or in the fall. The number of 499 or less is determined based on the day an employee makes a leave request. You look at your head count on the day the employee makes the leave request, and once the leave starts, the employee is grandfathered, even if the employer later grows in size to 500 or more employees. Let me first talk about the EPSL really quickly, the emergency paid sick leave. Alan Norton covered the 6 reasons you can qualify to get that sick leave, but let me just tell you real quick. 1, an employee is subject to a quarantine order. 2, the employee has been advised by a healthcare provider to self-quarantine. 3, the employee has symptoms and is seeking diagnosis. 4, the employee is caring for someone else that they have a relationship with and they satisfy the first 3 requirements I just mentioned. 5, the employee is caring for their own child if the child's school or daycare is closed or the sole child care provider is unavailable. And 6, in the future, there may be other reasons that qualify for emergency paid sick leave, depending on what the federal Department of Health and Human Services issues guidance on, but there's no guidance yet from HHS. In short, under the statute, full-time employees get as much as 80 hours, that is 2 weeks, of full pay for reasons 1 to 3 that I just mentioned, basically if they are sick and can't work or telework. And any employee who typically works less than 40 hours, that is, are treated as part-time employees under the statute, they get a 2-week equivalent of whatever their hours would have been, and they get that at regular pay, just like full-time employees. For the other reasons relating to caring for other people, employees get 2/3 of their pay up to the specified dollar limits on the slide there. Under the so that's EPSL. Under the expanded FMLA, just think of it this way. It is like traditional FMLA with 1 new reason for an employee getting leave, taking care of their child because of closed schools or lack of childcare due to COVID-19. The leave is up to 12 weeks a year with the first 2 weeks unpaid. And it's basically the FMLA with a new reason. The leave periods for on-site employees can be intermittent, that is broken up, not over a full week period, meaning you could do it day by day or even hour by hour, only if the leave relates to school or childcare reasons and both the employer and the employee agree. In other words, if the employee is sick and that's the reason why they're using EFMLA, he or she must continue their leave for the full COVID-19 incubation period. Let's go to the next slide, please. So Congress left it up to the Department of Labor to regulate small businesses, which have been defined by regulation as less than 50 employees, that is 49 or less employees. So essentially we have a statute here that only applies to employers who on any given day have 50 to 499 employees. This is purely a product of lobbying. There is an exemption for small businesses that is less than 49 employees for just the childcare and school closure reasons. Basically, if an employee seeks leave because of the childcare or school closure reasons, and that threatens the business, an officer of the company can make a determination to deny the employee leave. Now, my suggestion is that employers show some discretion here and approach this on a case-by-case basis, rather than making a blanket determination or declaration early on. You don't need to file anything with the Department of Labor, but you do need to document it by an officer of the company and keep it in your files so you can justify the decision later. There are three alternative reasons why small businesses can claim the business hardship exception. One is if granting the employee leave would cause financial obligations that are greater than revenues. This is not the same thing as saying you just don't like the cost of paying the employee leave. A second alternative reason is that granting the employee leave would risk the finances or operations of the company because the employee has specialized skills or knowledge or duties. And the third alternative reason for claiming this exemption is that the employer would not be able to find other employees who are able, willing, and qualified to do the job of the employee who's requesting the leave, and that employee's job is necessary for the business to operate. Let's go to the next slide, please. So I'm not gonna spend much time on this slide. This is about healthcare employees. Congress allows an employer, by the employer's choice, to exclude from coverage of the statute any employees who are either healthcare employees or emergency responders. The two exemptions, if the employer elects to take them, are very, very broad. I give you a summary here, but the full list is on the Department of Labor's question and answer page, where I link to at the end. I think the ostensible goal here was to keep healthcare workers working, and as well as first care responders, keep them on the job during the crisis. But the real reason for this is very simple. It's just a product of lobbying. The healthcare industry lobbied very hard to be excluded from the act and got that optional exclusion if the employer wants to take it. Next slide, please. So one question a lot of employers are asking is, how does the statute interact with pre-existing sick leave or paid time off policies or vacation benefit policies? And the answer here depends on whether we're talking about emergency paid sick leave or expanded FMLA, two different rules. So let me talk about the first bullet. For EPSL, the leave under the statute is in addition to whatever leave the employee was already entitled to. For the applicable 2 weeks of EPSL, the employee has the sole discretion on whether to claim emergency paid sick leave under the statute or accrued leave under the employer's policies or plans. The employer has no say in this. The goal is very simple, is to encourage employees with COVID-19 to stay home and not feel like they're risking some pre-existing right they had with the employer. The next bullet, the expanded FMLA, is a little bit different, quite a bit different. And it also depends on whether we're talking about the first 2 weeks or the latter 10 weeks or up to 10 weeks under expanded FMLA. So let's talk about the first 2 weeks. Those are unpaid under the statute. So either the employer or the employee can dictate or request or say to use the accrued leave through the employer's plan. This way, the employee, if they have that available paid time off or sick pay under the employer's policies, can top off their pay to get 100% of their regular pay. But for the remaining 10 weeks under the EFMLA, which is under the expanded FMLA, those 10 weeks are only for school closures or childcare, as I mentioned to you earlier. It's not clear what the rule is, but we think the rule is that the employer cannot insist on the employee topping off by using accrued paid leave unless the employee also agrees to this. We hope there's some inconsistent guidance on the Department of Labor's webpage under their FAQs 31 or 30, 31, and 33. And we hope the Department of Labor will provide more clarity on this issue in the near future. Next slide, please. All right, very quickly on the last two slides I have. This slide's about what kind of notice you need to provide to workers and how do you create a proper paper file or electronic file nowadays to document requests for leave. The Department of Labor has the usual requirements about giving notice to employees. Notice has to be posted conspicuously. It can be posted at work. You know, most employers post them in the break rooms or places like that. But given how many workers are currently at home, I would encourage everybody on this webinar to consider emailing or snail mailing the notice directly to the employees so they get it. You can use your own form of notice, but I don't see why you would. The Department of Labor has published a compliant poster on its website in 3 languages. Right now they published it in Spanish, English, and Korean. As I understand it, they will soon be translating it to 20 languages. I don't know which languages those will be, but I provided a link at the end. And if you keep monitoring it, you may see new language translations for the compliance poster. If you do nothing else, and this is my strongest advice today, get out the notice or post your poster or both in the next 10 days. If you do nothing else in the next 10 days, do that for the reason I'm going to talk about in a minute, which is compliance on the next slide. Well, go back to that slide though. I got one more point. Documentation. So Alan Norton did a presentation for the Chamber last Thursday. They touched on and covered pretty well the documentation requirements and gave a couple suggested leave request forms. I think those are still available on the Chamber's website, so you could use those. I will just add that the documentation requirements are somewhat loose. The initial request by the employee could be made informally on the first day of requested leave, even orally, like say a telephone call, with follow-up paper or electronic documentation later. Both the Department of Labor and the IRS have provided guidance on what documentation will be sufficient. Very little seems to be required in terms of proof of school closures or lack of childcare. For example, an email from a school or a daycare center or childcare provider would almost certainly be sufficient. The DOL seems to request, or require really, a note from a doctor to prove the employee actually contracted COVID-19 to qualify for the emergency paid sick leave, but that it's in conflict with CDC guidance, and it's very hard to get that documentation right now from a doctor because of the shortage of testing. So it remains to be seen how much the DOL will actually expect a positive test to give employees EPSL. I would encourage you, frankly, to just grant the leave if somebody says they think they have COVID-19. You don't want it in the workplace. All right, last slide. And I've given you a link to IRS guidance as well on documentation to get your tax credit later. Finally, a few quick words about how the statute will be enforced. The Department of Labor has agreed to refrain from pursuing enforcement actions until April 17th. So you get 10 more days before the government starts enforcing the statute. That'll be a month after the statute was enacted. And the reason they're doing that is there's just so much for employers to digest here. That's why we're doing seminars like this one. But keep in mind that while the Department of Labor says they won't enforce until April 17th, they are not giving employers carte blanche. If you want to avoid an enforcement action, you need to act reasonably and in good faith. That's according to the Department of Labor's regulations. If there is an alleged violation, let's say an employee complains to the Department of Labor and the department approaches you, you're going to need to agree to remedy the violation, both backward looking and forward looking. And the most important thing is no retaliation. You just got to avoid retaliating against employees who request leave under the statute. In my experience, and I'm sure everybody would agree with this, nothing bothers the Department of Labor more than retaliating against employees. That's the big no-no. Having said all that, private plaintiffs are allowed to sue under the statute. They can bring the same causes of action they could have brought in federal court or state court, really, under the Federal Fair Labor Standards Act or the FMLA. They can sue for minimum wages, liquidated damages, and attorney's fees. and they can pursue those claims on a group basis, whether it's an opt-in class action under the FLSA or opt-out class actions under the FMLA. Next slide. So that's my presentation. This slide gives you links. These are all hyperlinks. When you download them from the Chamber's website later today, you just click on them and you'll be able to go to the various resource materials. There's a lot out there, not just on the Department of Labor's website, but at my law firm has created a large site with all kinds of materials, not just on labor and employment issues, but various other things that might be helpful to your business. So that's it. And with that, I'll turn it over to Aaron.
Sorry, technology. We're all learning the Zoom way. I needed to unmute. So I thank Michael. I want to start by saying, and I know my PowerPoint is going to come up, but just like Alpanya started to say, teleworking is not a new phenomenon. Managing a workforce that is teleworking is not a new phenomenon either. It's just that there is a much more expanded teleworking force out there, and HR needs to play a role. And the fact of the matter is that your HR responsibilities as your HR manager or your HR team hasn't necessarily changed the functions, but the new reality of this pandemic, the new reality of the various labor statutes that are coming out and programs means that HR needs to be more proactive. Just like Michael mentioned with the posters. Yesterday, the department came out with a new OSHA poster. That poster also needs to be circulated. So you need to be aware when the Department of Labor issues these new posters as an HR professional, where they have to be posted in the workplace, but also since most of your workplace is teleworking, that you get out that notice. Those are traditional HR functions, but in this hyper intense reality that we have, we wanted to go through some of the things that we think will be very helpful for an HR professional to assist their entities, their organizations in getting through this, because we will get through this to the other side. There will be changes. Probably teleworking is here to stay in a much greater capacity than we've seen before, and that will create new reasons for HR to be more flexible and allow employers to be flexible, and that's some of the things that we want to talk about. The last thing I'll say before we go into the slides is this. In my view, it's HR's function here globally to manage the expectations of both the employees and the supervisors. There are things as we go through that we're going to talk about in which HR needs to step up because teleworking causes friction. It causes friction between employees who aren't able to work together. It causes friction because employees working from home or elsewhere have other distractions. Right now, I'm hoping that the people doing the lawn care across the street aren't necessarily revving up their motors because that will interfere with my presentation. And it's difficult for managers who are not used to managing their workforce remotely to make the transition. And you as HR professionals need to step up to help your companies weather this storm. Just like in a disaster, just like in a hurricane, answering questions, being available. So we'll start with the presentation with that overview. Let me also say this. You as HR people need to recognize that nationally, and this was just confirmed in a survey that was finished on my birthday, April 1st, most employees don't trust HR all the time. 1 in 5 don't trust them at all and will never go to an HR manager for an issue. Either they decide the issue is too small or they decide that they don't think they're going to get a solution. Over a third actually believe that HR is not there to help. That perception I'm not saying it's reality, but that perception is something in this teleworking environment that HR needs to overcome. And one of the most basic ways to do that is to A, be available, B, communicate consistently and clearly, and C, as I said before, be proactive. So let's go to the first slide. So the components of, in my view, of a practical strategy for HR to develop is have a plan for employees, have a plan for managers, communicate those plans to everyone clearly and succinctly, be prepared, for Murphy's Law. You're going to need to alter the plans or modify the plans. As this unfortunate pandemic continues past where we thought, companies are having to decide that they're going to have people out longer. Certain expectations for productivity are going to have to be attenuated, and you're going to need, as an HR manager, to be prepared to step in to help modify the plans. And finally, as Michael's presentation made clear, regardless of where you are, it's still HR's function to enforce not only the plans, but companies' policies in this new reality of teleworking, right? It is HR's function to identify, is somebody entitled to the leave if there's a question? It's HR's function to determine whether or not the paperwork that you receive is sufficient under the new guidance. It's HR's function to determine, to make sure that, for example, if a plan for employees and managers by the company is to reduce wages, that those reductions are done correctly, right? What you don't want to have is have an exempt employee whose salary is reduced below the minimum to qualify for an exemption, because they then become entitled to overtime and you have to keep track of their hours, right? The emergency laws have not suspended the application of other employment laws that you're familiar with. And we'll talk about that towards the end. Next slide. So what does a employee, the fact that not everything will go smoothly in transitioning everybody to a telework environment. That's why you need to be assisting in creating structure early. What do I mean by that? Well, employees are dealing with stress. They're dealing with uncertainty. They're dealing with illness. I liken an HR function like office hours. Remember when you had professors and they had office hours? I think a good plan so that HR is not overwhelmed is to set aside time, either daily or weekly, for being available for employees to sign up for time slots to discuss HR, to discuss their issues about pay, to discuss their issues about how the technology is working, how they're able to telework. Things they may not be comfortable telling their supervisors, HR needs to be set up to do so. Employees are also struggling with technology issues. I have that same problem. I don't have a large IT department, and therefore I'm trying to learn on my own, and I have to actually, I'm on this webinar on an iPad as opposed to a laptop or a computer because for some reason it wouldn't work. That leads to frustration by employees. I know I was frustrated, and HR needs to help manage instructional tutorials so that everybody is pulling together. And unfortunately, you need to recognize that not every employee can or is able to work remotely. And what do I mean by that? Well, there are various people for a variety of reasons. They're not used to the technology. They don't have, their home's not structured for the bandwidth you need. They don't have the equipment. they may need to be furloughed because they cannot work. They might be work available to them, but you and HR may need to make a determination that that person is not able to work remotely. There are also going to be other people who probably excel in a traditional office environment who may not be able to work remotely because of distractions, disconnectedness, the various things that happen when, you know, people have trouble either getting out of bed because they're not rushing or going to work. They don't have the structure. For those people, you with HR and in consultation with their managers may also have to decide that they're not available to work remotely and that you need to either downshift their responsibilities or maybe go part-time. There's nothing in the acts that Michael went through that prevent an employer from making changes so long as they make those changes legally and appropriately and without a discriminatory motive. Next slide. So HR needs to anticipate also, as it relates to an employee plan, that not all managers are good at managing a remote workforce. You and your staff may have to cover the gap because managers who are used to a traditional, they step outside, they tell somebody what they need to do, they go back into their office, they rarely communicate. You're going to see for the employer plan or the manager plan, that doesn't work in a teleworking environment. And so HR may need to step up to assist employees with the gap that's created by this lack of management. And as I said before, remember, you still have to enforce the employer's policies and employment laws. Next slide. So what's, in my view, the HR manager's role to manage managers and supervisors? Well, teleworking only works if people have deadlines and work expectations. And HR may need to step in because a number of managers who are used to getting significant productivity are not necessarily going to have that same productivity when they move to do teleworking, right? So I'll be honest, yesterday I had connection issues with my office. I was drafting a brief, which should normally take me about 3 hours. It was a 5-page brief. Well, with everything that was going on and everything else, it took me a lot more. Now, not going to charge the client for that. If my supervisors are on, sorry about that. But you've got to understand that things that you're expecting, that your managers are expecting, may not come out in the same time frame that they were working on. That's creating that friction that we talked about. Managers may think that the employees are, I hate to say the word goofing off, but are not concentrating on their work, that they're easily distracted. But the fact of the matter is that this technology system, as more people are using bandwidth, as more people in your own organization are getting online and taxing the server, connectivity slows down, work slows down. And so you need to remind managers, if there's nothing else in a manager plan, that they need to be patient and avoid frustration, okay? The work frustrations that are easily dissipated in a traditional office environment when people can talk things out, fester in a teleworking environment where there isn't an ability to easily communicate. And that's important. When you are talking to supervisors and managers, you need to remind them as HR managers and the HR department that they have to establish multiple communication channels with their reports. They can't just rely on emails. They can't just rely on an occasional phone call. There needs to be structure. And they also need to understand that Best thing about teleworking is, in my view, is that if you build flexibility into scheduling, you can build in a mandate for attendance when necessary. What do I mean by that? Well, for example, my connectivity at my home, once my kids are through with school, is much better at 2:30, 3 o'clock in the afternoon. So if somebody says, I need a brief tomorrow, calling me at 12 to say, have you finished it, is not really good, because I'm not going to be ready to do that. I'm letting my children have priority so they can get their schoolwork done. If you tell me that it's due tomorrow and I decide to work at 8 o'clock tonight, but I get you the deadline, that's fine. You need to be flexible, which means if you're flexible for your employees and you encourage that of your supervisors, if the supervisor says we're having an all hands call on Friday morning, then people can't opt out of that. That's the way you manage the expectations of both managers and employees. And again, just like you should establish periodic office hours for employees to sign up for, do the same for managers. They also need the help. You need to recognize that they're struggling. They're trying to learn this new arrangements. They're trying to figure out just like everybody else. Okay, next slide. So, HR responsibility for communications. This is one in which a lot of people I know who are used to simply interviewing people, hiring them, keeping employee files, occasionally getting progress reports or performance reviews, and update salary information for employees, are scratching their head and saying, I don't communicate. In a telework environment, HR needs to step up. The communications that managers are having with their employees has to function and focus on productivity. That means that it's HR's responsibility, in my view, to create the kind of community that exists when you have an office. What do I mean by that? Well, if, for example, if you do employee recognition, right? You get a group of your fellow employees together and they sit in a room and they're recognized, say once a month, or you have a birthday celebration. Do that as the HR people. Create those opportunities for social interaction virtually. Arrange, if it works for your business and your organization, to send care packages out to various employees. Make them feel like they're still part of the team, even though they're not all going to the office. Managers are currently, as Alpanya said, focused on trying to keep the business afloat. What HR needs to do to be proactive is keep the team culture, the employment culture alive by creating that connectivity. All right, one of the worst problems for teleworking is people get disconnected, right? The difference between extroverts and introverts, that's all not really the issue I'm talking about. Even people who are introverts, who like sort of breaking away from work and going and sitting and reading a book, get disconnected because they're not interacting on a periodic basis with their fellow employees and managers. So HR needs to create that conduit. They need to make sure that there's an established procedure for communicating the company's expectations of both employees and managers, and again, that everybody knows that. 2, they need to establish a procedure for obtaining feedback on those plans, because you may have a great plan, but if everybody has a problem with one aspect of it, you need to create a conduit so you know that. Again, like I said, team building and social interaction. I know some businesses that are having book clubs, that are encouraging employees that have same hobbies to get together, even on company time, to create that kind of break room chit chat that might happen. Those things help you and your organization keep engaged employees. And engaged employees and managers are what's going to get you through this teleworking, okay? Recognize emails are not always effective. I suggest to people that they do periodic check-ins. And that means that the HR people are calling people and saying, just, how's it going? What can we do? Do you need anything? Is there something we can do to help? That creates the kind of team consensus and camaraderie which is necessary for a telework environment to exist, right? It's no longer that you can invite people, even those people who may work from home or work in different offices, to come and meet you for a happy hour, right? The bars are closed, the restaurants are closed, most of our offices buildings are closed. You need to create that virtually to help people weather this storm. Next slide. All right, this is the Murphy Law slide, right? Recognize that not every program you hear about is going to be right for your organization. A program that works for an organization that's in a small community that speaks the same language may not work for a company that's international, in which you're trying to create issues or create connectivity between people who have language barriers or time zone issues or the like. Be flexible. Remember what I said, build in flexibility, and then you can build in mandates. Recognize the longer the situation continues, we're going to need to adjust or plan accordingly, right? The lawyers who are on this call just know the Florida Supreme Court said, we told you trials might continue in May. Now trials can't start till after July 6th. And in some places in the country, they're not probably going to exist till August or September. You need to have a contingency or a change in plans to manage not only your employees and managers' expectations, but manage the expectations of your customers. Recognize that the company may need to call upon consultants it hasn't previously employed, okay? Mental health professionals, right? Having somebody on staff, or at least as a consultant, may be very helpful. Having a business coach, people who can help your workers make the transition to teleworking, to some of the lack of supervision, to some of the way that you are addressing the issues of connectivity, you may need to hire counselors. And again, listen to feedback. Make sure you plan for it, make sure you have a conduit for it, and once you get it, make sure you listen to it. Next slide. All right, and this is the one that reminds you that you still have traditional responsibilities. All right, just because unfortunately there's a pandemic out there, you still have to be the people that are enforcing company policies, right? There are various policies that haven't been modified as a result of teleworking, right? You still have anti-harassment policies. You have accountability policies. If you require receipts for, expenditure and reimbursements, those policies haven't been thrown out the door just because we're working from home and there's a pandemic out. As I said before, and as Michael alluded to, the various employment laws and the requirements created by those laws still exist. The FLSA still exists. If you have to pay people overtime, you have to pay people overtime. If somebody needs an ADA request, Americans with Disability Act request, you have to honor that request if they're entitled. HIPAA, right? Just because if you know somebody, even though the Department of Labor has reduced or changed some of the enforcement. I can ask somebody for their temperature. I can ask them to put a thermometer in their mouth if I'm actually standing with them in a business office. Those things may have changed, but HIPAA's requirement that you keep information about employees' medical conditions private have not. Employees may choose to share, but you as the HR manager need to remind supervisors that they are not to share employees' health issues with other people in the business. OSHA, that's a big one, right? OSHA still exists, and As everybody knows, when you have people who are teleworking, their homes or their office space now become your workplace, which means if they're injured during work hours, they may be entitled to workers' compensation. And you should make sure that your insurance carrier is aware of the changes. The last thing I'd like to leave you with before we accept questions is this, right? It's not that HR's functions have changed, but a proactive HR department, proactive HR manager is going to be able to foster engagement among coworkers and deal with the intensity that is created by the immediacy of enforcing the new rules that Michael made reference to, right, under the CARES Act and under these emergency leave procedures. Thank you very much.
Great. Well, thank you, Aaron, and thank you, Michael. Those were both excellent presentations. And while you were speaking, we received a lot of great questions. A lot of them focus on the FFCRA. And Michael, let's take the first one from Yanin, who asks whether once an employee receives their 2 weeks or their 80 hours of emergency paid sick leave, and then their child or their spouse becomes sick, are they entitled to another 80 hours of paid sick leave?
No, yeah, the EPSL is one time. If there's another reason that comes up after that 2 weeks, fall under the statute, you have to take it under the expanded FMLA. And that means either normal FMLA reasons or under the expanded statute, just childcare or closure issues.
And I'd like to add to that too. You know, obviously you're talking about the Emergency Paid Sick Leave Act, and your question talks about both a child and a spouse. And Michael, you know, made a great point earlier in his presentation. This emergency FMLA is just one additional reason to take FMLA leave. And so if your child, for example, and that limited exception is if your child has their child care issues because they're home from school or their child care provider has closed. And that gives you access to emergency FMLA leave. So the fact that your child or spouse becomes sick, then we're talking about a regular FMLA application. So that person would have to suffer from a serious health condition, would have to submit the same sort of paperwork, would have to go through the same process in terms of applying for regular FMLA leave. But Michael's exactly right. You wouldn't get an extra 80 hours, and you would look to the other provisions to see if you qualify for the emergency paid sick leave.
Patrick, let me just add one thing to that. If the employee contracted COVID-19 before April 1st, when the statute went into effect, there might not have been coverage, obviously, under the statute. But let's say the employer had already granted the employee some sick leave. Then, if the employee gets sick again after April 1st with COVID-19, then they do get the 2 weeks under the statute of EPSL.
Right. The next question comes from Adriana, and I think this one is for you, Aaron, and it really touches upon, and maybe you can amplify the point that you made about being able to discipline employees for non-performance. Her question is, what responsibilities do I have during these times? Can I fire an employee for underperformance?
Sure. The statute doesn't require you to keep people, right? There are incentives, which we're not going to talk about in the tax portion. That will be a program, a different program that you should look for the chamber to be putting on, right? In terms of employee retention credits and the like. We're not talking about that. But the emergency acts that we're talking about, the CARES Act, does not alter an employer's right to terminate, discipline, or suspend an employee for infractions of employer's policies. So long as, again, so long as you're doing it for legitimate reasons, right? If you find out before an employer comes to you that an employee is tested positive, let's say for coronavirus, and you decide to terminate them before they come to you to take their sick leave or their, or their Family Medical Leave Act, you would violate the law, right? Just like previous to this pandemic, if you found out that an employee had cancer before they came to you to ask for FMLA leave, and you decided to terminate them solely to prevent them from using that FMLA leave, you would have a violation. But if somebody is supposed to work and they've been given a project and they're supposed to give you 20 hours on the project and they don't, and you don't think their work product is good, you have the acts don't require you to accept substandard performance. You may exercise your traditional rights to discipline up to termination.
Agreed. And I think one thing, and this is something we have to keep in mind even before this, and that those are retaliation claims. So I think we want to be extra careful in terms of being able to establish the reasons for that termination so that we can say this was independent of any sort of protected activity for taking leave or emergency sick leave. But you do, like Aaron and Michael had pointed out, these things can be done, and certainly you have to document them. But I think we probably need to be a little bit more careful so that we can avoid what is probably the easiest claim to make, is in a retaliation claim. Let's go to our next question. I guess we have Yanine again, who's asked a question about teleworking. In her business, she has lots of work to be provided to employees, but she has employees who, for one reason or another, cannot work. For example, one who says that she has 2 kids at home and she can't work, and another one who says that she's come down with the COVID-19 symptoms. Do these individuals qualify for any sort of leave under the statute, Michael?
It depends. Let's start with the second one. If you contract COVID-19 or believe you have the symptoms and are seeking a diagnosis, you definitely qualify for the emergency paid sick leave, whether you're doing on-site work or teleworking. That's an easy one. The second one's an interesting question. It depends on the reason why you're claiming you can't telework. If you're just claiming your kids are a distraction and you can't get anything done around the house, it's up to really the employer to determine whether the employee is capable of teleworking. The statute doesn't really answer that question. What the statute says is if the employee is being offered work by the employer and the employee cannot do it because of school closures or childcare, absence of childcare, then the employee can make a claim for the expanded FMLA. It's hard for me to tell from the question which way they would go here, but if the employer believes the employee should be able to do the telework and the employee's claiming they can't because of the childcare provider's not available, that sounds like it might qualify for FMLA. The employee needs to make that request.
And Michael seems to raise an issue that I think a lot of employers are going to have to face in terms of being able to track these employees. So, for example, if your childcare issues prevent you from being able to work during normal business hours because you're taking care of your child, but you are able to do that after hours, again, for those non-exempt employees, we want to be very careful about tracking the hours that they spend working so that you can avoid any sort of claims of, I work 50 hours in a week and then therefore I'm overtime.
Right, just to Aaron's point earlier, if that employee could do the work, the telework after the children went to bed, the employer's got a good argument, then the employee is expected to do the work.
Right, and again, to add to Michael's point, as long as you're flexible, right, you're not requiring them to potentially attend a meeting that they can't, say between 9 and 12 when the kids are up, that's fine. That's why we talked about being flexible. And I agree with Michael, if there's a way for the employee to do the work at a different time and you're not enforcing a strict schedule, then they may not qualify for some portions of the leave because they're actually able to work. It's not that they've been prevented from working.
Exactly.
The next question deals with in terms of, and I think, Michael, you covered this in yours, but you may want to expound on the documentation that you can require from employees when they do apply for the various leaves under these 2 new acts. This person requested some documentation from the doctor. Is that okay?
Well, I'm not sure what it means. Is it okay? The DOL, well, first of all, it depends on what the reason is. If the employee's seeking EPSL because the employee or he or she is claiming they themselves believe they have the virus, Department of Labor, as I mentioned, seems to require you get a positive test and a note from a doctor saying that. It's hard to believe they're going to be able to enforce that. The testing is just not widely available yet. And under current testing criteria, you can't even get the test unless you exhibit certain symptoms. So what I would suggest is the employee does try to get a note from the doctor. A lot of doctors I know right now are doing this over the phone. They're examining their patients by talking to them on the phone. And if the employee reports certain conditions, the doctors are saying, don't come into my office, just stay at home and call me if things get worse. And they're telling them to then go to the hospital if they get to advanced lung issues, breathing issues. So the documentation is all listed on the Department of Labor's website. It's things like the employee's name, the date of the requested leave, the reasons for the leave, and then if they're claiming emergency paid sick leave, I would encourage them to get something from the doctor. It has to at least be documented. The same for the EFMLA. Who's the person you're caring for? Are you the sole child care provider and you can't do it for some other reason, like you're sick, or could somebody else take care of the children? Things like that. Just document the reasons so they seem to provide the support for the tax credit at the end of the year.
And remember, I think one of the reasons for emergency paid sick leave is if you're exhibiting COVID-19 symptoms and seeking medical attention. So in that, arguably, you wouldn't need a doctor's note in that particular circumstance.
Correct. As long as you're seeking a diagnosis, that alone is reason number 3 for claiming leave under the statute.
Our next question is, I think it's from Adriana again. And here's an issue that a lot of companies are facing in terms of how they're dealing with the various options they have to cut costs. And here, what sort of issues should she be looking out for if we cut hours or just close for a few weeks is her question.
We could probably both talk about this. The statute is not intended and does not interfere with the ability of businesses to decide whether they have work, can do the work. You are entitled to furlough employees or lay them off during this period. You don't even need to justify it. You can make your ordinary business decisions. And if there's a furlough, and I know this is somebody else asked this question, so I'll just answer it now. If there's a furlough or you shut down and you're not offering work to the employees, they do not get the leave under either portion of the statute. Work must be available to them for them to claim EPSL or expanded FMLA.
Right. So, and I would just add to that, while all of your options are available, remember, you still have to comply with the other laws. So if you decide that, if I took all of the women, okay, no offense to the various attendees and the like, but if I said, I'm worried that, that people who are B+ positive are more likely to get COVID. And so I want to test you all my employees. I'm going to test them to get their blood type, which is information I might not normally have. And then I'm going to send all of the people who are B positive home because there's I don't say there's a rumor, but there's a conversation going on in the medical community that B+ positive people, and I don't want to start a panic, are more susceptible to this than anybody else. I may have run afoul. I may be trying to do the best, but I may have actually run afoul of various employment statutes because I just asked for information I'm not normally entitled to. So you have to, when you're deciding to reduce the workforce, the other thing is make sure when you reduce the hourly pay that you're not reducing it beyond minimum wage. The minimum wage laws still apply. The minimum salary to cover an exempt employee still applies, right? The $35,000 and change, which means I've had this question asked. If you're trying to reduce your pay and you reduce everybody by 20%, but that takes a manager who might be making $40,000 down to 32, you've just created an employee who is no longer exempt and is entitled to overtime if they work the hours. So you need to recognize that when you make changes to your workforce, either in the size or in the pay structure, that you do so in conjunction with, not ignoring, the other applicable laws. But you're still entitled, again, to reduce your workforce as if the CARES Act had never been passed.
And I'd only add to that, these changes that we're talking about be done with notice. I mean, it's easy to think about that, but a lot of companies should remember that, especially if you're talking about lowering the salary of an exempt employee, a salaried employee, you want to provide notice before you do so, because obviously you can't retroactively lower their compensation. All right, let's go to the next question. And I think we have several questions that relate to the total of 80 hours. And here, Tatiana is asking whether the 80 hours total for both employees and family members being sick, or do we need to track the FCCRA paid sick leave and for the, well, let me just answer it. It's just 80 hours, Michael, and you can chime in, but you don't get an extra 80 hours. Once you take the 80, you've exhausted the benefits that you're entitled to under the, for emergency paid sick leave.
Correct. You've answered the question. It's a one-time 80 hours between April 1st and December 31st of this year. If there's additional reasons that qualify under the statute, you've got to take a FMLA, traditional FMLA, or expanded FMLA due to school closures or lack of childcare. It's as simple as that.
It's as simple as that. And her follow-up question is, how is family defined? Is it the same as FMLA? And I think what I'll do is I'll take her question is because under the Emergency Paid Sick Leave Act, there's talk of caring for an individual, and under the Extended Family Leave Act, there's the provisions that allow you to care for your child, your son or daughter. So in terms of individual, what does that mean, Michael?
So the Department of Labor has anticipated this. If you go to their question and answer page, they define the kind of people. They don't define it in terms of family. They define it in terms of who is the person you can be taking care of, or whose school is closed or can't get childcare, and whether that qualifies. So it's basically biological children, adopted children, anyone for whom you have court-appointed guardian responsibilities. Let me put it this way. The DOL anticipated this and says it's pretty much anybody that you would be expected to care for. It cannot be somebody you never would have cared for otherwise. For example, you can't just volunteer to help somebody who lives across the street or across the hallway in your apartment building and claim credit for that. It'd be nice of you to do that. It's a great good deed. It doesn't qualify under the statute.
All right, let's go to the next question from Ashley Franco. She has part-time staff and part-time staff who has no one to care for their child during school closures. And her question is whether that someone who's part-time is eligible for the entire 12 weeks under the Extended Family Medical Leave Act.
I mean, Patrick, do you want to just answer that?
Yes, they are.
Yeah.
I mean, the simple answer to that is yes. When you calculate under the paid sick leave, they're not entitled to the full 80 hours, obviously. And so if they tried to supplement the first 2 weeks of unpaid, it wouldn't be, the entitlement is not 80 hours. It would be something more akin to what they work in a 2-week period. And if you can't determine that, there's provisions to expand upon how do you determine the amount, but it wouldn't be the full 80. Next question comes from Elizabeth, and the exemption for less than 49 employees, the small business exemption, does that apply to the emergency paid sick leave?
Yeah, well, yes. The exemption for small businesses defined as 49 or less applies to either of the two statutes, emergency paid sick leave or EFMLA, but only if the request for leave is based on school closure or inability to obtain childcare. That's the trigger. And if you're a small business and the employee is asking for leave for one of, well, that reason, either school closure or lack of childcare, then you have to go through, have an officer of the company make the determination of one of the three reasons I listed in my slide has been triggered, document that, put it in your file, and then if you're ever questioned about it, you can prove why you claimed the exemption.
So to be clear, it seems like this is something that the company can go ahead and do as opposed to wait for an agency certification that they apply, they qualify for the exemption.
In fact, not just that they can do, that's the way the statute works. You do not need to apply to the Department of Labor for the exemption, but you need to document it. And the reason you need to document it is, first, the IRS is going to potentially review your records later. And if you get challenged by the Department of Labor or a private employee lawsuit, you're going to want to have your documentation.
Next question is from Jacqueline. Actually, it's a great question that recently got answered by the DOL. And that, Michael, is if an employee has already, prior to this COVID-19 crisis, had already taken 12 weeks of FMLA leave for a serious health condition, are they then now entitled to another 12 weeks under the extended family medical leave?
Okay, so let's see if we agree here. I think the answer is no. It's an expanded reason for leave, not a new right to leave. And so if you've already taken your leave this year, that's it.
That's right. That's right. I mean, when it first came out, that was a big question that we really didn't know the answer to, but the DOL issued some guidance and clearly said that it's not an additional 12 weeks. So if you took the full 12 weeks, or if you took 4 weeks or 5 weeks, you only get the 6 additional, or the whatever is remaining on the 12 weeks.
Can I jump in here for
Sure.
1 second? The other thing, though, is that the DOL has made it clear that you can't modify your policies for taking PTO.
Great point.
So, right, so if you've required people to give you 2 weeks notice to take PTO, you can't require them now to give you 4 weeks notice. You're stuck as of March 18th with whatever your PTO policies are. That doesn't mean, as we said, that the leave is somehow expanded and you get double the rights, or that somehow if you only give people 8 days of PTO a quarter or 8 days for the year, that you're required to give them more days, but you can't reduce your PTO policies. And it's important for people to notice that, because I think that got snuck in there without people really paying attention.
Great point. Great point. Next question, and frankly, I can just answer it without giving it to the both of you in terms of the date this takes effect and when the entitlement begins, and that was April 1st under both the emergency paid sick leave or the extended family medical leave. It's all comes into effect April 1st, and no, you do not get credit for what you provided prior to April 1st. Next question is from Katrina. And here, Aaron, this sort of on the theme of terminating an employee, but here an employee's contract ends and they are on sick leave, emergency paid sick leave, or if they are on expanded family medical leave, can we terminate their employment upon the end of the contract?
You guys can disagree, but I think the answer is yes. There isn't anything in either act that requires you to keep an employee, but you can't prevent an employee from taking leave that is available. So if they are on emergency paid sick leave for the 80 hours, they're entitled to that. You can't truncate that. If they're on emergency family medical leave because they've hit, as Michael keeps pointing out, the sole reason, the additional reason, then you can't do that. If they're on pregnancy leave, you're not entitled under the Anti-Pregnancy Discrimination Act to change the terms of their employment. But if their contract runs out, you're entitled to, you don't have to renew them. This is not, neither of these acts, I think it's fair to say, is a employee or mandated retention of their employment workforce, right? Certain rules still apply. If for example, the Warren rules apply and the statute applies, you have to comply with it. But there's nothing to stop you from deciding not to continue somebody's employment once their contract runs out.
Agreed, agreed. And I would only point out that in those I've litigated those issues before, where employers tend to think of a contract as an end date and the ability to terminate. But in practice, a lot of times employers will renew a contract. And so you should still keep in mind that that's an employment action which an employee can certainly target in a claim, that failure to renew the contract. So just because a contract ended doesn't mean that someone can't complain that you failed to renew my contract because of some protected reason. Next question comes from Michelle. And a question of, if an employee is out because they've tested positive for the COVID-19 virus, what can I require them to show me to ensure, before they come back to work, to ensure that they no longer have the virus?
So I'll take, Michael, I'll take this one for a second. I know that there are hospitals who are requiring 2 tests for, 2 negative tests for employees who want to come back. I know that Jackson has implemented this. I know there are other medical facilities that have implemented it, and they've implemented that they have to be, if I remember correctly, I don't remember which one, it's 2 negative tests taken at least 2 weeks apart. Okay, so that's, I don't know the standard, that's a standard, but I know that's what locally certain medical facilities are doing. And you may be guided by some of the things that the CDC are telling employers to do in terms of letting people back into the workforce.
The interesting thing is that the statute only gives 2 weeks of EPSL, even though, as I understand it, the medical experience so far is some patients could have the disease for as long as 28 days. The question posed here is just not answered by the statute or the Department of Labor guidance. It's just not. The first 2 weeks, if the employee claims leave, it can fall under the EPSL portion of the statute. After that, there is no guidance. I don't know what to say, except if the employer wants to be comfortable that if people don't have the disease, I don't think the statute prevents the employer from having such a policy.
Yeah. Next question, and admittedly, I actually read an email on this, but I'm sorry to say I don't know the answer, so hopefully Aaron and Michael will have it. But this particular person hired someone prior to the COVID-19 crisis, and their concerns is in terms of onboarding that individual. For example, how do I onboard the individual and get the I-9 notarized and physically inspected, physically inspect the required documents that they're being provided? Do either one of you touch on this? I mean, obviously, if you don't, I can certainly look it up, but I just thought I'd give it to one of you.
I don't know the answer to that. Look, the rest of the law hasn't changed. So all other onboarding laws or paperwork requirements still exist.
Michelle, feel free to, oh, go ahead, Aaron.
No, I was just going to say, I'll say this as a practical matter. Since the state of Florida has allowed for notarization virtually, you may be able to get around you may be able to complete the requirements by getting certain things notarized and as sort of remotely, if you're willing to accept it. But I don't know the exact answer that the DOL would give for that. So sorry, I don't know the answer.
The DOL has not addressed this yet.
And Michelle, if you send me an email, I do have an immigration partner that has dealt with that, this whole issue of being able to onboard with the I-9.
I also think, Patrick, somebody who's on the call just answered the question or said that they had an answer for that. Let me see if I can scroll down.
It says Homeland Security is allowing virtual onboarding through Skype.
Oh, okay.
Yeah.
I don't believe that. I have no reason to not believe that.
All right.
Right.
Here's another question. I'm not sure, it might be a little bit outside the scope of what we've spoken about today, but in terms of an employee claim for short-term disability, can they both apply for that along with the extended leave pay?
Disability and EPSL?
Actually, disability and extended family leave.
So the statute just doesn't talk about disability, period. In general, the concept that seems to be running through all the IRS and DOL guidance is no double dipping. Yeah, I guess you can claim it, but the employer is only going to get one tax credit at the end of the year for one of the reasons. You can't give it twice. So that's all I can really say about that.
Yeah. A question from, and I'm just going to remind everyone in terms of the SBA loans that'll be the subject of another webinar that we put together, and that we specifically aren't going to be focusing in on those questions in this particular webinar. So the next question we have is from Anna, and she asks about an employee who cannot work because they are high risk, because they are at a high risk to contract the COVID-19 virus. They've been offered work from home, but the person refuses. How do they deal with that particular individual?
So I think this is very easy. If the employee's been offered telework and they refuse it, they don't qualify under the statute. Work is available. There's lots of DOL guidance on this. And if the telework is available and the employee chooses not to do it, there's no coverage under the statute. However, if the employee is afraid to come into work and the employer is not offering telework, what the employee needs to do is claim reason number 3 for EPSL, which is that the employee has been advised by a healthcare provider to self-quarantine because of that employee's high-risk situation. That's the only thing that would qualify. It would only get you the first 2 weeks.
Agreed. And I think, room for one more question. We have time for one more question. This question is, can I reduce pay on specific employees? For example, can I reduce the salary of employee A by 20%, but employee B by 10%?
Yes, the statute just doesn't interfere with this, and the DOL says that employers are entitled to adjust pay. Just be careful that you don't drop people between minimum wage, and be careful of trying to monkey around with the salary basis test and treat people, well, all the normal rules of the FLSA still apply. Aaron, were you going to say something?
I was going to say the same thing. That's what we talked about. The fact of the matter is, you just have to make sure that when you're reducing somebody, you're reducing them for a legitimate business reason and not for something else. And there's a bunch, small shops who are reducing, say, family members by less than the regular, other people who are non-family members may find themselves, facing some questions about how those choices were made. But if you have, just regular business reason to do so, there's no reason that you have to reduce everybody consistently. You can be inconsistent.
Just be careful that the people who are 20% are not all women or all of
Right.
protected class, but other than that, you're entitled to do it. I think that about covers everything. I'm sure you guys have additional questions, and I invite you both to contact Aaron or Michael or myself, and I'm sure EK can even chime in with some answers, as many employees as she's got over at FIU going through there, that she's probably run into just about everything herself. I'll turn it back to, I'm not sure who I'm supposed to turn it back to. Turn it back to EK. Go ahead.
Patrick, before you do so, I think Alfred wanted us to remind people that the Chamber has a website, https://www.miamichamber.com, COVID-19 Business Resource Guide. So people can find other information and other things on the Chamber's website. So with that, I will.
And our emails are in the chat. So if you click through the chat at the end, they were just posted. If you want to contact us, sending us an email. And now EK.
Awesome. Thank you guys so much. That was everything we asked for in usual Chamber fashion. We promised relevant content with incredible experts, and we delivered. Thank you, Michael. Thank you, Aaron. Thank you so much, Patrick. And listen, Michael says, if you don't do anything else, get those posters distributed and get those posters posted in the right places. And Aaron reminded us that engaged employees are what's going to help us get through this. So this was such great information. Thank you guys so much. And to all of our attendees, listen, I want to thank you you, each of you, for your hard work and leading your organizations through these unprecedented times. Your involvement in this webinar speaks loudly of your own commitment to ensure that you have the best information possible to help your organizations through all that's going on. So stay tuned. You're going to have more great webinars to come through the chamber. As attendees, you will get a copy of these slides as well as the recording. And I'm sure that'll be sent out to you all that have registered. Again, I want to thank you immensely for joining us. On behalf of our president, Alfred Sanchez, our board chair, Felipe Basuta, and our vice chair, Patrick Martin, we want to ask you to have a safe and healthy rest of your work week and continue to work great remotely. Thank you so much. And want to say also a shout out to our chamber staff. Oh my goodness, however could I forget to say Stephanie, Tanya, Spencer. Thank you guys so much. We really appreciate all of you. Thank you so much.
Great.
Have a great afternoon.
You too. Thanks.